Karunanidhy garu, who is a well-known figure among OBC intellectuals and workers. And he is serving for the OBC cause, Shudra cause, for the past many years at national level. And with this issue, he is directly connected with the case that is filed in the Apex Court of India. And he is well known for his oratory skills and the subject content related to Sudra OBC communities. I welcome Thiru Karunanidhy garu. At present, he is holding the office of the National General Secretary of All India OBC Employees Federation, which is a very, very important organization working for the welfare of OBC employees across the country. So welcome, sir. And I request him delivering his lecture. Please.
I can start now?
Yes, sir. You can now.
Okay. Good evening, and a warm welcome to all my friends. Professor Murali Manohar sir, then the organizers of the OBC Mahasabha. Voice is audible, huh?
Yes. Audible, very much audible.
Right. So the topic today is about the judgment given by the Supreme Court of India on 7th November 2022 relating to the validity of the constitutional amendment, 103rd amendment, that empowers the union government and states to provide 10% reservation to the economically weaker sections for those people who are not covered under Article 15.4 and 16.4. 7th November has to be taken by the subaltern communities of this country, the backward classes, the scheduled castes, the tribes, the minorities, as a black day. Why I am telling like this, with all due respect to the judiciary, that the constitutional validity of a new philosophy, that is reservation on the basis of the economic criteria, is being upheld by a 3:2 majority of the Supreme Court of India Constitution bench. I would like to remind our friends that it was on 7th November 1990 when Savior of Social Justice V.P. Singh announced the implementation of the recommendation of Mandal Commission report to provide 27% reservation for the other backward classes in central government jobs and public sector undertakings. The very same forces who are working all along in the history against the welfare of the social groups containing the backward classes, scheduled castes and tribes, they ensured that this government headed by V.P. Singh is thrown out of the government. That was a black day for the social justice forces in 1990. After nearly 32 years, now we are facing a similar situation where the judiciary has also come in favor of economic criteria and against the social justice. Friends, it has to be remembered that the concept of economic criteria has been continuously rejected both by Supreme Court as well as Parliament in the earlier prior to 2022 7th November judgment. The first constitutional amendment, Article 15(4), was passed in Parliament on 1st June 1951. The reason for bringing the first constitutional amendment was, till then, the then Madras Presidency, presently Tamil Nadu state, which had some areas of Andhra Pradesh, Kerala, Karnataka, that was a composite of Madras Presidency, was having a 100% reservation in the name of communal reservation, communal roster. That was implemented by the Justice Party, the non-Brahmin movement. The first jiva came in 1921, but that was not implemented. So in 1928, again the Justice Party implemented the communal reservation, providing 100% reservation to all the communities. It may not be called a proportional representation, but it gave representation to all the communities. Ironically, the Brahmins also got reservation. For every 14 seats, 2 seats were given to the Brahmins, 2 seats to the backward classes, 2 seats to the scheduled caste, one to Anglo-Indian and Christians, one to Muslims, and 6 seats to the non-Brahmin communities. Like that, the total 14 seats were reserved to various communities. Until 1950, when the constitution came into effect, that was implemented in the Madras Presidency. Once the constitution came into effect on 26 January 1950, the communal order was challenged in the Madras High Court, citing the constitutional provisions of Article 14, 15, etc., that it is against the Equality Code. So Madras High Court said that the communal roster is against the Constitution, hence the order is null and void. It was struck down. Then the government in Madras, the Congress government, they made an appeal in the Supreme Court of India. There also the Supreme Court upheld the Madras High Court judgment and said that this communal GO is totally against the Constitution provisions and violative of the Constitution. It was struck down. Thereafter, immediately there was an uproar in Tamil Nadu. There was agitation process in Tamil Nadu led by the social revolutionary Thandai Periyar. The other leaders like Peradinga Anna, they all joined with him, supported him. Then leader Kamarajar, who was in the Congress government, he also lent his support in a governmental way. So the agitation went on for nearly 1 year, from 1950 up to 1951. That made the union government, headed by then Prime Minister Jawaharlal Nehru, openly telling the parliament that there are certain happenings in Madras province that necessitated to bring the first constitutional amendment. That was a very word he used in the parliament, because the constitution came into effect only in January 26, 1950. Immediately within 1 year, an amendment is coming. So the members were really agitated or perplexed as what to be the reason for bringing this amendment. So Nehru explained that this is the happening, and if it is not arrested, this flame may go to other states also. So he wants to put a full stop for that. So he wanted to bring an amendment with the help of the then law minister, Babasaheb Ambedkar. So the first constitution came into effect, Article 15(4), that gave the powers to the states to provide reservation for education. But the constitution till then did not have a provision for reservation in education. Article 16(4) that provided reservation in employment was available. So this first amendment that provided the states the powers to bring reservation in education, not only for Madras presidency, but for the entire country due to the agitation led by Periyar. So the first challenge on the new republic came to social justice only. So when the constitutional amendment came, there was some discussion, debate in the parliament. Ambedkar, while bringing the first constitutional amendment, he brought the very same verse that was available in Article 340, socially and educationally backward classes. So Article 15.4, we could find the very same verse, socially and educationally backward classes. So some of the members were claiming that we can amend like this, that is socially, economically backward classes. But Pandit Nehru as well as Ambedkar rejected that argument. They said that the economic criteria is not static, it is elastic. Whereas caste in this country is always rigid. That can be an identifiable representation, whereas economic criteria cannot be an identifiable representation. That was the discussion that finally went for voting also. As nearly as 243 members of the parliament voted in favor of social and educational backward classes. Only 5 members voted in favor of economic criteria. So when the constitution came into effect and the first constitutional amendment also was brought in, this economic criteria was totally rejected by the parliament. Thereafter, when VP Singh brought this 27% reservation, then that was challenged and the stay was given by the Supreme Court of India. His government was also thrown out. The new government led by P.V. Narasimha Rao, he came. He brought a GO in 1991. That GO said that 10% of reservation can be given, may be provided to the economically poor sections. The very same bill which we are today discussing, which is the Supreme Court has upheld. He brought a GO. That was also challenged in the Supreme Court of India. The 9 judges bench in the Indira Sahni case, they said that unanimously that economic criteria alone cannot be a factor for to provide reservation. So 9 judges bench also rejected this economic criteria. So what we are seeing today is the parliament is bringing a backdoor method of providing a reservation on the basis of economic criteria alone. That bill was brought on January 8th, 7th January 2019. The bill was discussed in that ministry. Next day, it was passed in the Lok Sabha. 9th January, it was passed in Rajya Sabha. 12th January, President gave the assent. In the entire history of constitutional law that was passed in Parliament, this 103rd amendment is the only bill which was passed in such a bullet speed or rocket speed. So the forces that are dominating the bureaucracy, the forces that have assumed power in the parliament, they were able to ensure that without any discussion, without any commission, without any data, a bill can be passed to their advantage, simultaneously affecting their social justice concept. So the bill, many of the parties, it is very much unfortunate that many of the parties also supported, thinking that this will benefit the poor among the upper caste. But that is not going to be in effect also. All these parties, with ignorantly or knowingly, they supported the bill. It was the Dravida Munnetra Kalagam from Tamil Nadu, the Rashtriya Janata Dal, the Union Muslim League, they only opposed that, but they were in minority in 2019. They didn't have any mixed support. So the bill was passed in Parliament. Immediately we challenged it in the Supreme Court of India in 2019 itself. Many of our petitioners, they have challenged it. The DMK has challenged it. The Vidudalai Sirthayal Katchi, led by Tirumavaran, they also challenged it. The Muslim League, one part, they have also challenged it. Many of the individuals have also filed. but the matter was not listed. It was admitted, it was not at all taken for discussion. Only at the fag end of our former Chief Justice retiring, period to 1 month, this case was taken up immediately and continuously 5 days the debates went on, and finally the judgment 3:2 ratio, it was that constitutional amendment has been declared as valid. So what we are seeing today is what was not accepted by Parliament in 1951, what was rejected by a 9 judges bench in 1992 has come into effect through a constitutional amendment which is against the basic structure of the constitution. That is what I am not saying. The dissenting judges, Judge Ravindra Bhatt and also Chief Justice of India, Lalit, who also concurred with Ravindra Bhatt, both of them say that it is against the basic structure of the constitution. Whereas 3 judges, they upheld the validity of the constitution. So now we have to know what is the various things in that judgment also. When Ravindra Bhatt was saying in his dissenting judgment, 2 important areas, which through our council, we have focused or we have presented or we have submitted in the Supreme Court of India. Number 1, before that I want to read the statement of objects and reasons for the bill which the government brought. The reason for bringing this bill is, the reason is given that economically weaker sections of citizens have largely remained excluded from attending the higher education institutions and public employment on account of their financial incapacity to compete with the persons who are economically more privileged. So the main reason for bringing the bill was that the economically weaker sections, which in the reference consists only of the upper caste economically weaker sections, not the other people, BC or SC or ST. Only the upper caste, that economically weaker sections, they have got a financial incapacity, so they were not able to enter into the public employment as well as in the higher education institutions. So the first point which we have raised through our council was, this financial incapacity is an economic term. It cannot be addressed through a social objective. Reservation policy is a social objective with an aim to address the social inequality or social injustice that has been going on historically for so many thousands of years. To compensate that, a reservation policy has been implemented through a constitutional provision in the constitution. Whereas the economic, that incapacity, it has to be addressed only through an economic measure, through the form of scholarship, or the concession in fees, free hostels, or whatever may be. All these economic measures can only address this social, that is economic inequality. That was our point, submission before the learned judges. The other thing was, they amended Article 15, they brought 15.6 and 16.6 by amending the Constitution. 16.6 says that the states have got the powers to provide reservation to the economically weaker sections in the matter of public employment. So I would like to remind our friends that what is there in the Constitution. Article 16.4, which is available previously, it says, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the services under the state. So, the main criteria for the backward classes, scheduled castes and tribes to have a reservation in employment is there should be inadequate representation for them. If there is adequate representation, a reservation policy need not be applied to them. This is Article 16.4. Whereas Article 16.6, which they have amended, has cleverly removed this word of inadequate representation. So, the economically weaker citizens in the upper caste, whatever may be the representation, it can be inadequate or more than adequate, that need not matter. We have to provide reservation. So there is a difference in the approach by the government. On the one hand, the historically discriminated people of OBC, SC, ST, for them the reservation should be on the basis of inadequate representation, whereas the other group, which is based on measured on the basis of economic terms, has been provided reservation. Even without any adequate representation, they can avail the reservation. This is the great difference, and they have delinked this part from the Article 16.4, which is against the basic structure of the Constitution. That is what Justice Ravindra Bhatt, in his judgment, he says like that. So this is one or two parts which through our council we have focused, which dissenting judges, they have also accepted that. The other point which we have focused was, when you are giving an economically basis reservation, it cannot be only to a particular group. It has to come across all the sections of the people. So whether it is SC, ST, OBC, minority, whomsoever it may be, when you are identifying economically weaker sections, it has to be implemented across all the people, whereas the 103rd amendment applies and only to upper caste and excludes these people, social groups. That is one of the contention by one council, which our Justice Ravindra Bhatt also has said that this amendment totally excludes the majority poor people of this country, and hence it is against the basic structure of the Constitution. So on this basis, he says this constitutional amendment is invalid. So these are the things which the judges have put on that. But finally, on the basis of 3:2, on the basis of 3:2, the constitutional amendment is valid. So the danger is there today before us that this constitutional amendment, if it is going to be implemented further, will totally derail the concept of social justice and the various measures that has been brought by the sacrifices of our leaders all these years. That will be totally sidelined and finally removed. And this economic criteria will be replaced. This is what the Sanadana forces, which have been always propagating all these years. So finally, through Parliament as well as the judiciary, they have succeeded in that. So on this matter, I would like to tell our friends that on the basis of economic incapacity, financial incapacity, this provision is based on that. Whereas data shows, which have been taken by very senior researchers, which has been published by the Economic and Political Weekly of 8th June 2019, that says that economically these weaker sections from the general category, that is upper caste, share 28% in 445 NRIC ranked higher education institutions. So these so-called economically weaker sections among the upper caste are already 28% in higher education institutions. Whereas the bill says they didn't have the capacity to enter into that, which is a wrong information given in the Parliament also. And in almost 50% of these education institutions, their share of representation is more than 20%. This is what the data says. Whereas the government doesn't have any data. For backward classes, all these years, these people have been suppressed, neglected, historically discriminated. All these years in the name of Manu law, they have been deprived education. They have not been given any social status. So to address all this social injustice, the reservation policy, one of the measures on social justice is reservation policy that was brought in. Whereas in the case of these economically weaker sections, among the upper caste, there is no historical discrimination. They have not been denied education. They have not been denied employment. They have not been denied entry into the temples. They have not been denied entry to take water from the well. So no social discrimination has been ever imposed on them. On the contrary, it was these forces who went against these backward classes, scheduled castes and tribes in preventing social justice for them. So today what we are seeing is oppressors as well as the oppressed are treated equally. This is what is happening today. So the oppressors who have been oppressing the majority people in the name of caste, they have also been given in the name of caste today 10% reservation. Now, as regards the representation of this economically weaker section of the upper caste, the data shows even after 75 years of independence and reservation provided to the scheduled caste and tribe from 1960 onwards, the reservation in employment provided to the OBCs right from 1993 onwards, the representative of these social groups has not even touched more than 10% in the group A in the top level positions. That is the position today. I can give you statistics. Among the 889 secretaries in Union Government of India, the representation of OBC is 0. The scheduled caste is only 3. Tribes are only 2. So totally among 18 and only 5 are there. In the Supreme Court of India today, out of 32 judges, only 1 OBC, 1 SC. So this is our representation after 75 years of independence and after implementation of reservation policy. So the top bureaucracy of this country is fully dominated by the upper caste to the extent of 90 to 95%, and still then they are demanding their economically weaker sections among them exclusively to the extent of 10%. Means the intention is that the dominance of these groups should always be provided. It should always be permanent. That is the intention for which only they have taken this economic criteria. And slowly, this will be spread to other areas also like backward classes and scheduled castes and tribes. Already there is an imposition of creamy layer on backward classes. Many of the eligible backward classes today working in the public sector undertakings and government departments have been deprived of this reservation policy. Consequent upon which, many of the seats in the educational institutions of higher excellence, they are now not filled up, automatically transferred to the general category. This is what is happening. Many of our people, poor people who have joined IIT or IIM, they were not able to continue inside the campus because of the atrocities committed by these upper caste people through faculties and the students, and many of the dropouts, if you can calculate, which was also informed in the parliament, that these people have not been able to study well because there is no support from the faculties, because all these faculties are dominated by the upper caste. If you look at any IIT or IIM or AIMS, you can see that at the professor level, nearly 95% or I can say 98% of these posts are being filled by the Brahmins and other upper caste. So our people were not able to take on the studies inside the campus. So after entry, after 1 year, slowly they are coming out, and some of the students also commit suicide, like Rohit Vemula, or here also our IIT Madras. Like that, so many girls, so many students belonging to the deprived sections, they only commit suicide. This is what is happening today. So that system will continue if this 10% EWS is also allowed to be implemented in the coming years. This is the greatest danger that is before us. So we must address all these issues. That is why we filed a petition before the Supreme Court of India. We thought justice will provide. However, with all respect to the judiciary, the various points which have been raised have been taken very well by the dissenting judges, and the majority judges are not in favor of that. On the contrary, the majority judges are saying that the concept of reservation policy on the basis of caste should be totally removed. This is what the observation of the majority judges. They say, how long you will continue this reservation policy? Having said so, they upheld this 10% reservation for the upper caste. This is the irony. On the one hand, they say reservation should not continue, it should be made a full stop. By that, they should have struck down this constitutional amendment. Then there is a valid point for them. Whereas they have allowed this, and they say that caste system, this caste-based reservation policy should not be continued. Whereas, if you look into that, these socially backward classes, educational backward classes, caste is not the only criteria. If you go into the Mandal Commission report, you can see he has identified 11 factors. He has taken the educational backwardness, economic backwardness, social backwardness. On the basis of that only, various castes have been identified. That is why in the OBC Mandal list, you can find some castes belonging to the minorities also, from the Christians, from the Muslims. Some castes are also there, identified, because the Mandal report does not go into the mere caste alone. It has gone into the caste also as a primary factor. But apart from that, they have taken the educational backwardness and also the economic backwardness. And if you come out of 21, if you are crossing 11 only, that caste have been included. That is a system that has been adopted. Whereas here, the bill says those who are not covered under Article 15.4 and 16.4. So who are they? They are non-OBC, non-SC, non-ST. That means they are upper caste. They don't want to say upper caste or forward caste. Whereas Ravindra Bhatt judge has clearly stated that this criteria is only towards the benefiting forward caste only. He has made in his judgment. He has exposed this myth that it is to all that. Some people are saying that EWS is among to the poor. Whereas our Ravindra Bhatt has clearly stated that this reservation is totally excluding the majority population and only focused on the forward caste only. That is the judgment he says. So it is only to the forward caste. And also they said that now they are not using the word economic intersections. In the various programs also in the North Indian channel, I can find that it is for the poor. There is no question of poor. The criteria fixed by the government for EWS, if it is totally laughing stock, 8 lakhs per annum is a poor, is called a poor, is called an economically weaker sections. That means every month he is earning 66,000. Per day he is going to earn 2,220 rupees. If he is called a poor, I think the total world will spit at us. Whereas if you are economic, what is the below poverty line, which the government says maximum 100 rupees per day. If you calculate that, yearly 36,000, you are calling below poverty line. Most of this 95% are OBC, SC, ST below poverty line in this country. Whereas for economically weaker sections, they have fixed their criteria of 8 lakhs, 5 acres of land, 1,000 square feet of plot. All these things are called economically weaker section, means they are bent upon totally eradicating, removing, annihilating the social justice. That is the very idea of this Sanathan groups. That is what they have been propagating all these years. Now, since the government with the majority is there, they were able to pass in the parliament. And most of these political parties, without knowing all these things, they have also supported that history will not forgive them. The social justice forces, we cannot forgive all these people who voted in the parliament also. So it is very much necessary today that on the one hand, we have to oppose this economically weaker sections, reservation 10% to the upper caste, not on the basis that those people should not get anything. We are also for reservation for everybody. We want proportional representation if they are acceptable. If they are ready, let them bring proportional representation like what was happened in Tamil Nadu during Madras presidency period. Communal reservation, you identify, you collect the data of all the communities. Proportionally, you give the reservation. No one will object that. Whereas here, you are giving a caste-oriented reservation for the upper caste without any data. 10% was taken without any data. There is no commission. Nothing is there on the government to say justify how that they have fixed 10%. That case is already there before the Chief Justice Chandrachud. Already that case is there. He has already asked the question how that you have fixed the same 8 lakhs which is applicable to the OBCs also. What is the rationale behind that? He has also questioned the 10% reservation. That case is going to come in the coming months. We will know how our present CJA is going to react on those submissions by the Government of India. But Government of India doesn't have any data of 10% or fixing the 8%. They immediately constitute a committee headed by Pandey. What the Pandey committee says, he doesn't provide any data for 8 lakhs. They say 8 lakhs can be given, nothing wrong like that. They have said that. That is all the committee has given. So that is all will be questioned with the Supreme Court of India. On this judgment of EWS also, the petitioners are going to file a review petition in the Supreme Court of India. So the case will come before the same bench only. But now the ex-former CJA has already retired. The new CJA is there. Let us hope. We will present all these points which our Justice Ravindra Bhatt and concurring judge also CJA, they have also concurred certain points, very valid points. They have stated that on these points they have invalidated the constitutional amendment. All these points will be again remanded before the Supreme Court of India, and we will demand that it should be taken to a larger bench, because already 9 judges bench of Indra Sahani has upheld the validity of social and educational backwardness. It has rejected the economic backwardness. So that all these things will be focused when the review petition will be filed before the Supreme Court of India when the arguments are coming. So the one factor is on the judiciary side, our petitioners will be moving. On the public side, it is like the intellectuals who are assembled today. You have to take this message to nook and corner of this country, because there is being created a myth that this EWS is towards the poor. It is not so. The 8 lakh criteria means the upper caste, particularly the Brahmins, they will be the beneficiaries. The other caste can go nowhere near the Brahmins, because already they are in the top level of bureaucracy. They know how to maneuver the things, and they will be only the major beneficiaries. Here and there, 1 or 2 people may get it. That cannot be a justifiable solution. So we have to explain all these things. We have to explain to the people that we are not against the poor people. Already you can see various measures were taken by various governments to address the poverty. In Tamil Nadu today, we have got a 7.5% to the students who are studied in the government schools. They can go to the higher educations, including the professional colleges. The government said all the 7.5% students who got admission to the professional colleges, their entire fees, including the hostel fees, will be reimbursed by the government. That is a welfare measure. That is what the government should do. Here 7.5% means it is not applicable only to SC, ST, OBC. Any student belonging to upper caste also, if he studies in a government school, he is eligible to avail the 7.5%. That is called a welfare measure. That is why we call it as a Dravidian model. Our Chief Minister boldly says Dravidian model means this is what? Everything for everyone. That is the basic ideology of the social, our Dravidian movement. So many welfare measures we have taken. And the government is giving a free bus pass to the women. Yet all women. There is no segregation among that. Only SC or ST should board the bus. That is not the criteria. Any lady, irrespective of the community, she can board the bus. It is free. That is called a welfare measure. Whereas the Government of India has brought in a backdoor method of providing reservation, which is not at all constitutionally permissible. With a brutal majority, they have postulated, and the judges also 3:2 only they have upheld that. All the judges unanimously, it is not a unanimous judgment, it is only a 3:2, which can be contested in the review petition, and it can be taken to the larger bench, and it is for our intellectuals to spread the message that the EWS will be totally against the welfare of all the sections of the people. And if at all a solution to everybody has to come, then we should say that proportional representation. That is the final solution. Till then, no way this economic reservation should be implemented. We have to oppose that tooth and nail at all the places, for which all these our friends who are hearing this, please spread the message and to all the people, particularly to the political parties who voted for this bill. They should be first awakened, Because ignorantly they think it is for the poor. It is not for the poor. It is only for the dominance of the upper caste, particularly the Brahmins, in the bureaucracy, in the employment as well as in the education, and to deny the majority sections back to the previous pre-independence era, where the people were not given any education or employment. That is the main essence which we have to focus. With this, I thank the organizers for giving this opportunity. Thank you, friends.
Professor, question and answers now. Any
voice?
Yes, sir.
No. Any questions?
Yes, thank you.
Thank you.
Karunanidhy Garu.
Yeah.
Thank you very much for a very valuable speech, lecture with vast information in a short span of maybe half an hour or so. You have given out so much information to all of us. Thank you very much for this. Yes, all the intellectuals who are attending. I hope. And now I invite any of the participants to please raise any queries, or if you would like to give any suggestions also, you can please kindly speak on any queries that can be just asked to Karunanidhy Garu.
Sir, it is Dr. M.A. Malik.
Yes, sir, please.
Yeah. Sir, it's okay. The legal fight in the judiciary will go. But the thing is, unless it will reach the masses and agitation takes place, I don't think government will withdraw it.
Yeah.
So what are your inputs for the educating the mass? Because it is only understood by the educated section only. It is very hard to convince the mass for the agitation in this area. Please simplify it to educate the mass and making them to come out of the homes. Please, sir.
Yeah, actually, that is what I was focusing that also. That is, apart from our legal battle, we should create the public opinion. That is always good. That is what Periyar did all his throughout his life. You please mute everyone and allow me to start, because some disturbance is there. So we have to focus on the public opinion also, for which we have to take simple messages only. So because the supporters of this reservation, they say it is to all the caste. That is what they are creating a situation. They are giving any false information. It is not like that. It is very clear that is only to the upper caste. Particularly, it will help the Brahmins only, because your criteria of 8 lakhs, all these things will benefit them also. And they are already on the ladder for so many years. And their other, their brothers or relatives, everybody is in the top level positions. So they can only occupy this 10% major. But here and there, some people may get it, but then that is very negligible. So the majority beneficiary is again the upper caste, particularly the Brahmins, number one. So it is not to poor, it is only to the so-called, the name of economically weaker sections. Again, they want to dominate. Number two, we have to tell that this reservation is going to affect the entire majority sections of the population. In the sense, our SC, ST, OBC, they constitute nearly 85% of the population of this India. So if you bring this economic criteria, then naturally the concept of reservation policy is not to address this economic issue. It is about our social status. Whether I am rich or poor, in this country, by birth, I am treated in a particular community where it has got its own criteria about my status and other things. If you want to remind our friends, what happened to our Babu Jagajjeevan Ram? He was the Defense Minister of India. He was also Deputy Prime Minister of India. He is a rich person, knowledgeable person. He went to Banaras Hindu University to unveil the statue of Sampurnanand through remote. He didn't even touch that statue. But after he went away, the entire Brahmin students and other people, they said it has been it has become impure because Babu Jawahirlal Nehru has unveiled that statue. They conducted various rituals by which the purity is being brought. This is what happened to Babu Jawahirlal Nehru, who is a scholar, who is a rich person, who is also a minister. Like that, I can quote so many. So here, by birth itself, your status is decided in this country. It is not my denial of education. Historically, was not based on my economic thing. Whether I am rich or poor, I am denied because I am a Sudra in my Manu law. So we have to explain that this economic criteria totally will become totally against the interests of the SC, ST, OBC. So we are fighting this case. If we want social justice, by social justice only, various measures have been taken. Today, whatever we are today is because of the social movement only. Because otherwise, whatever forefathers were being, the same will have continued for us also. So if you remove the social justice class, then again we will go back, generations will go back to the pre-independence days, where we will be denied everything. That is what they are doing. This is not mere 10% reservation. They have got other areas also. They have got a national education policy. You can see from that how they have totally removed. There is no word about reservation policy in the education policy. You can go through that. There is no mention about reservation. That is what they say. They have coined a new word, disadvantaged sections. There is no explanation about that. So like that, they have cleverly bringing that new education policy. So through education policy, our entry in various streams is being rejected or stalled. You cannot go beyond certain stage. They are conducting every level. There is an entrance test. Next year onwards, even if you pass MBBS, you cannot go PG course by marks alone. They are going to introduce a test called next. Only by that, if you pass, you are eligible for PG. Otherwise, you have to remain as an MBBS. So who will go? Who will be able to succeed? Those who can afford for coaching. So like me, again another coaching for next. Likewise in the education policy, after 12th, you cannot go for graduation. There is another test called common entrance examination like NEET. If you pass that only based on the mark only, you can apply to some colleges. So like that, our people belonging to SC, ST, OBC will be deprived. So all these are combined factors. They have put one block one side, other side they are bringing 10%. So like that they are fixing so many, what I can say, they have so many blocks which will affect the OBC, SC, ST. So like that we have to explain to the people. Let us go to the various areas. You bring small leaflets in your languages so that the common man will address. But before that, the political parties have to be awakened because it is they who supported that. They have to be informed. What you have done in the parliament is against social justice. You have done injustice to us. So you have to again go to the parliament and say that it should be removed. This economic criteria is wrong. So another thing which I have not mentioned in my speech was this 50% ceiling. All along, these backward classes have been restricted to 27%.